Okay, let's unpack this head scratcher. You're hunting for an apartment in Taiwan, right? And you see a listing for something called an illegal construction for rent.
Yeah, illegal,
Yeah,
but rentable.
yeah,
Sounds like a total contradiction.
exactly. What is going on there? That's the puzzle we're tackling today. We're diving into whether these O can actually be leased for homes.
hmm
And if Taiwan's act governing the development and management of lease housing market, well, if it has anything to say about it.
And what's surprising, like right off the bat, is just this possibility. A structure built against the rules, but it's someone's home,
Hmm.
potentially with a proper lease agreement.
Yeah.
So to get to the bottom of this, we've looked at some legal analyses, a really key Supreme Court judgment. That's case number 103-202, OPA SOCA.
Okay.
The thinking behind the Lease Housing Act itself and, some other helpful background stuff.
Exactly. Our mission for you, the learner, is to try and make sense of this legal gray area. We want to give you the core knowledge about renting these kinds of places in Taiwan. Maybe some unexpected angles and useful takeaways without getting totally lost in the legal weeds.
Definitely.
So let's jump in. Can you actually rent an illegal construction to live in?
Okay, here's a surprising place to start. In Taiwan, the law generally respects agreements people make. Freedom of contract.
Right.
So if you agree to rent a place and someone agrees to let you use it, that contract is usually valid. Unless the basic purpose is illegal or like against public morals.
Okay. But the building itself is illegal.
That's the key difference.
Yeah.
Building it was against the rules, sure. But just renting out that existing structure for someone to live in, that act itself, it's generally not seen as making the rental agreement automatically illegal.
Ah, because the purpose providing housing that's legal.
Precisely. The problem is with how the building was built, not necessarily the agreement to live in it.
Okay, that makes sense.
And this is where it gets interesting. Think about that Supreme Court case, the 103-3A Sava one we mentioned.
Yeah.
The court actually ruled against the renter in that case. But the whole argument was about what happened during the lease of a property that had illegal additions, which then got torn down by the city.
So they were arguing about the consequences.
Exactly. The court never said, oh, this lease was invalid from the start just because parts of the building were illegal. No, they argued about who was responsible for the losses when those illegal parts were demolished.
That's a really important distinction. The court basically accepted the lease existed, enough to argue about it.
Right. And what's also fascinating, legally speaking, is that Taiwanese law recognizes something called de facto power of disposition over these illegal structures.
De facto power. Okay, what does that mean practically?
Think of it like this. Even if you don't have the official ownership papers for, say, a shed you built in your backyard without a permit, you still control it, right? You use it, you benefit from it. And yes, you can even rent it out. It's tied to this idea that these structures are often seen as fixtures, attached to the land under the civil code.
Okay, so even without full legal ownership, there's this recognized, practical control that allows for renting it out.
That's the idea.
Yeah.
And it's maybe helpful to know there's sort of two main types people talk about. You've got substantive illegal construction, CO. These were
Yeah.
built without any permission, like from the ground up, totally off book.
Right.
And then procedural illegal constructions. These might have had some legal basis initially, but didn't finish all the paperwork, like getting the final registration done.
Both lack full legal standing, though.
Correct.
Yeah.
But they exist physically, and people often live in them.
Okay, so let's recap this bit. Generally, signing a lease for an illegal construction to live in Taiwan, that agreement is probably valid between you and the landlord.
Mm-hmm.
It sets out your right to use the place, your duty to pay rent. The illegality is about the building itself, not necessarily the act of renting it for housing, which is a legal purpose.
That's the general view, yes.
Now, what about the Lease Housing Act, the SUH? Does that law apply to these rentals of, potentially dodgy buildings?
Right, that's the next big question. What does this act actually cover? Article 3 defines lease housing, SODE, simply as buildings leased for residential use.
Okay, so the key is residential use. Why someone's renting it?
Exactly. And here's another bit that might surprise you. The official reasoning, like the notes explaining why the law was written this way,
Yeah.
specifically says it applies even if the building doesn't comply with building regulations or land use rules.
Seriously, it says that.
Pretty much verbatim.
Ugh.
The legislative reason states that the definition includes properties regardless of whether it complies with building management or land use control and other related regulations.
Wow. Okay, that seems pretty clear then. So even if it's technically an illegal construction, if someone's renting it to live in, the Leased Housing Act likely applies.
That's the general understanding, yeah. Based on the law's wording and how it's been interpreted, our sources seem to confirm that even uncussed, rented as homes usually fall under this act.
Are there any exceptions then? Situations where the act wouldn't apply to a residential rental, even if it happens to be an illegal structure?
Yes, there are some specific exclusions listed in Article 4. Things like short-term rentals for tourism, government-run housing, cooperative housing, and very short leases, like under 30 days.
Okay.
But critically, the legality of the building itself, not listed as an exception. One of our sources even has a handy table showing this, whether the place is legal or not, doesn't automatically take it outside the Act's scope for residential leases.
So the act sets some ground rules for the rental relationship, like limits on security deposits, who fixes the leaky roof, how you end the lease, even if the building itself shouldn't technically exist.
Exactly. The Lease Housing Act provides a kind of baseline framework for the rental agreement. But, and this is really crucial, it does not make the illegal construction legal.
Right, it doesn't fix the underlying problem.
No, that building still faces the very real risk of being demolished by the authorities.
It sounds like the law is trying to do a bit of a balancing act here, protecting tenants, maybe vulnerable ones, while still acknowledging these buildings are, well, illegal.
You've really hit on a central tension. The Act aims to offer some protection, perhaps because for some people, these might be the only affordable housing options available.
That makes sense.
But then you have that Supreme Court judgment, the 103-03-7 one.
Yeah, the awareness thing.
Right. It shows that if a tenant was aware that the building was illegal when they signed the lease, that knowledge can seriously limit their ability to claim damages if it later gets torn down.
Okay, let's really dig into that Supreme Court case. What actually happened, and why is this idea of the tenant's awareness so critical?
So in this specific case, you had someone rent a property. Part of this property included illegal additions, like extra rooms built without permits. The renter's plan was to renovate these additions and then sublet them as individual studios.
Right.
They spent money doing this.
Right, invested in it.
Exactly. But then, oops, the city authorities came along and demolished the illegal parts.
Ah, so the renters sued the original landlord.
Yes. They sued for damages, trying to get back their renovation costs, rent they lost because they couldn't sublet anymore, and also money they had to pay their own subtenants because their leases got cut short.
Makes sense they'd try. And the court's decision.
The renter lost.
Yeah.
At every level, district court, high court, all the way up to the Supreme Court.
Wow. But again, the court didn't say the original lease was just invalid because of the illegal bits.
Correct. That's key. They didn't throw out the lease.
Yeah.
Instead, they analyzed the duties and responsibilities that came with that lease agreement.
So why did the renter lose then? This awareness factor must have been huge.
Absolutely central.
Yeah.
The court basically said, look, if the renter knew these additions were illegal when they signed the lease, and if the landlord didn't specifically guarantee or promise that these illegal parts wouldn't be demolished.
Which they probably didn't.
Right. Then the demolition is essentially a risk the renter should have foreseen. It's a risk they accepted when they signed the lease, knowing the situation.
So the landlord isn't necessarily on the hook for the damages.
Not necessarily for what the law calls incomplete performance of the lease obligation. The court's reasoning was kind of like, if you knowingly take on a risky situation, you can't automatically blame the other party when that known risk materializes.
It's like the court said, you knew what you were getting into. Caveat emptor, almost.
That's a good way to put it. The court pointed to several things. The renter was in the business of subletting properties. They did expensive renovations, and the illegal additions themselves were described as easily recognizable or obvious.
So circumstantial evidence suggested awareness.
Pretty much. Based on all that, the court concluded the renter was aware of the illegality when they signed. One of our sources actually has a useful table laying out the facts, the claims, and the court's reasoning on this awareness point.
So this awareness acts as a kind of factual limit on the landlord's usual legal duty, the duty to provide a usable property under the Lease Housing Act and the Civil Code.
Precisely. Normally, yeah, the landlord has a duty under Article 8 of the Lease Housing Act and Article 423 of the Civil Code to provide and maintain the property in a condition suitable for the agreed use, like living in it.
Really?
But the Supreme Court ruling clarifies that if the renter knows about a fundamental flaw like the fact that it's illegal and could be torn down, that knowledge really changes the dynamic. It limits the landlord's responsibility if that specific known risk actually happens.
And what about this legal term attributability? How does that fit in when claiming the lease wasn't fully performed?
That's another piece of the puzzle. Generally, under Civil Code Article 227, if you want to claim damages because a contract wasn't properly fulfilled, the failure needs to be somehow the fault of the other party. It needs to be attributable to them.
Okay.
In the context of renting an illegal construction, if the renter knows it's illegal, the demolition by the government isn't necessarily seen as the landlord's fault, legally speaking.
Because the renter knew the risk was there.
Exactly. The renter accepted the property with that inherent risk. The fault, in a sense, lies with the illegal nature of the building itself, a fact the renter was aware of. So it's harder to argue the landlord is solely responsible for the consequences of that illegality.
Okay, this awareness factor is clearly the linchpin for anyone involved with renting an illegal construction. Let's shift gears slightly and talk about the rights, obligations, and, well, the risks for both sides.
Yeah.
Let's start with the landlord. What are their duties and potential headaches?
All right. For a landlord renting out an illegal place for someone to live in, they still generally have obligations under the Lease Housing Act, assuming it applies.
Like we discussed.
Right. So things like limits on the security deposit they can ask for, according to Article 7. The basic duty to provide and maintain a habitable place under Article 8.
But with that huge asterisk about tenant awareness we just covered.
Exactly, that massive caveat from the Supreme Court case. They also need to follow the rules for terminating the lease laid out in Articles 10 and 11. And Article 13 says they need to be truthful in their advertising.
But the biggest risk for them is still the obvious one, right? Demolition.
Absolutely. That's the elephant in the room. Losing the building, losing the rental income. Then there's the risk of disputes with the tenant if it is torn down.
Though their liability might be limited if the tenant knew.
Correct, if they can establish that awareness. And then, totally separate from the lease, they could face fines or penalties from the building authorities for the illegal structure itself. That's a whole different legal track.
It sounds counterintuitive, but one of the sources hinted that a landlord might actually want to disclose the illegal status clearly.
Yeah, it's a strange sort of risk management thought. By putting it in writing in the lease, tenant acknowledges parts XYZ are illegal constructions. The landlord could potentially strengthen their argument later that the tenant was fully aware.
Based on that Supreme Court reasoning.
Right. It could help limit their liability for demolition-related damages, but it's definitely a double-edged sword.
How so?
Because you're also creating a clear written record admitting you're knowingly leasing out an illegal structure, which might not look great if building authorities get involved for other reasons.
Good point. Okay, now flip it. What about the tenant? What rights do they technically have, and what are the big dangers?
Well, if the Lease Housing Act applies, the tenant does get some protections on paper. Rules about security deposits, ensuring fair contract terms under Article 5, things like that.
But the risks seem huge.
They are. The number one risk is sudden eviction due to demolition, losing your home.
And getting compensation for that.
Very difficult, potentially impossible if they were aware of the illegality when they signed the lease. That Supreme Court case suggests they'd have a hard time claiming money for demolition-related losses, moving costs, finding a new place, money spent fixing it up from the landlord.
So the burden is really on the potential tenant to be careful. Due diligence.
Absolutely crucial. You really need to look carefully at the property. Are there parts that look obviously added on, maybe different materials, weird shapes? Be wary of rent that seems way too good to be true.
Red flags.
Yeah, definitely. Maybe try checking official records if that's feasible, though it can be tricky. And if you have serious doubts, seriously consider getting some legal advice before you sign.
Because awareness can be assumed.
Right. The Supreme Court case shows it's not just about what you were explicitly told. Your profession, the renovations you plan, the obvious physical state of the building, these can all lead a court to conclude you must have known, or at least should have suspected.
And trying to write something into the lease like, landlord pays if demolished.
You could try. But if your awareness is later established, a court might still say you accepted the primary risk, potentially overriding that clause depending on the specifics. It's legally uncertain.
This whole situation feels very much about information, who knows what, when. How does the law try to balance this information asymmetry?
It tries. though imperfectly.
Mm.
As we said, the landlord's liability might increase if they knew it was illegal and the tenant genuinely didn't and couldn't reasonably have figured it out. The landlord has a duty not to deceive.
But conversely,
Conversely, the tenant bears much more risk if they were aware. That Supreme Court case really hinges entirely on the court's assessment of the tenant's level of knowledge or awareness.
so if the facts were different, say, a tenant who truly had no clue, maybe hidden illegal structures, and a landlord who deliberately concealed it.
The outcome could be very different. The court's view on attributability, whose fault it was, might shift significantly towards the landlord in that scenario.
And the Lease Housing Act tries to help with this information gap.
It does try, yeah. Provisions like Article 13 on truthful advertising aim to reduce that asymmetry. But again, as the Supreme Court case demonstrates, obvious physical signs or the tenant's own expertise can still lead a court to presume awareness, even without explicit disclosure. One of our sources also includes a table that summarizes responsibilities based on whether the tenant was informed.
Okay, let's try to pull this all together. To wrap things up, what are the absolute main takeaways here? Can you rent an illegal construction? Does the Lease Housing Act apply?
Okay, the two big answers seem to be yes, you can legally enter into a residential lease agreement for an illegal construction in Taiwan, and that lease is generally considered valid between the landlord and tenant.
Got it. And the second part?
And yes, the Lease Housing Act generally applies to these residential leases of illegal constructions, provided they're used for dwelling and don't fall under those specific Article 4 exceptions like tourism rentals.
And it feels like there's always a but here.
There are huge buts. The biggest is the unavoidable inherent risk of demolition. That hangs over everything.
The act doesn't stop the bulldozers.
Exactly. The Lease Housing Act sets rules for the rental relationship, but it does not legalize the illegal building itself or shield it from enforcement action.
And the other massive but.
The tenant's awareness. Knowing, or being deemed to know, about the building's illegal status when signing the lease is absolutely critical. As that Supreme Court judgment makes clear, it can significantly limit or even eliminate the landlord's liability for damages if the place gets demolished.
That awareness factor is key.
It really is. It's also maybe worth quickly noting again that the Lease Housing Act's definition of lease housing focuses on residential use. This is broader than, say, the Maine Housing Act's definition of housing, which typically requires a legal building with an official house number. This difference highlights that the Lease Housing Act is deliberately trying to regulate a wider range of actual living situations.
Even the precarious ones.
Possibly. The policy thinking might be to provide some baseline protections for vulnerable tenants who might not have many other affordable options, even if those options are technically illegal structures.
So based on everything we've discussed, what's the practical advice for people maybe looking at one of these places or even already living in one?
Okay, for potential renters, extreme caution. Do your homework thoroughly. Inspect the place with a critical eye. Look for those red flags, weird additions, rent that's suspiciously low.
Don't just assume it's okay.
Yeah, definitely not. Try to check official records if you can. If you have any real doubts, seriously consider getting legal advice before signing that lease. And understand the risk. You could lose your home and any money you put into it, potentially without compensation from the landlord if you were deemed aware.
And document everything.
Yes. Keep copies of the lease, all communications, maybe even photos or notes about the property's condition, and anything that looked potentially illegal. Also, know your limited rights to terminate, like if the place becomes demonstrably dangerous under Civil Code Article 424.
Okay. And for landlords who are renting out these kinds of properties?
They need to be fully aware of their obligations under the Lease Housing Act, assuming it applies. They absolutely need to understand the implications of that Supreme Court judgment regarding tenant awareness and how it affects their potential liability.
And the disclosure idea.
It's something to consider carefully, perhaps with legal counsel. Transparently disclosing the illegal status in writing might limit liability based on the court's reasoning, but remember that double-edged sword, you're creating proof of leasing an illegal structure.
And definitely don't lie about it.
Absolutely not. Avoid any false guarantees or misleading statements about the building's legality or safety. That could definitely backfire.
So the bottom line for both parties.
Extreme caution is the name of the game. Ideally, both should seek legal advice before signing a lease for a known illegal construction to fully grasp the risks and potential consequences. Honestly, renting a legal, compliant property is always the safer path. The Lease Housing Act's intervention here is kind of a patch-up job for this gray area. It tries to inject some fairness into the rental contract itself, but it doesn't fix the root cause, the existence of the illegal buildings. Addressing that requires much bigger solutions in urban planning, housing policy, and effective enforcement.
So for you, the learner, the key takeaway really is renting an illegal construction in Taiwan. It's legally complex, it happens, the lease can be valid, and the Lease Housing Act often applies.
Mhm.
But the huge risk of demolition is always there, and what you know, your awareness of the illegality is absolutely critical in determining who bears the loss if the worst happens.
Which leads us to maybe a final thought to leave you with. Given how widespread illegal constructions are and the very real housing affordability challenges in Taiwan, what are the broader societal implications of this situation where we kind of allow and even regulate the renting of these illegal spaces?
Yeah, what long-term solutions could actually address this complex issue beyond just tweaking contract law?
Definitely something to mull over.
For sure. We encourage you to maybe look up the Lease Housing Act, perhaps even that Supreme Court case, if you're feeling ambitious, and consider the ethical dimensions here for both landlords and tenants caught in these tricky situations. Thanks for taking this deep dive with us.